Get ready? Start. 49. On a reading of the aforesaid judgments, what emerges is that the power to grant remission on an application filed by the convict or on his behalf, is ultimately an exercise of discretion by the appropriate government. Stop. It is tried that where there is exercise of legal power coupled with discretion by administrative authorities, the test is whether the authority concerned was acting within the scope of its powers. Stop. This would not only mean that the concerned authority and in the instant case, the appropriate government had not only the jurisdiction and authority vested to exercise its powers, but it exercised its powers in accordance with law, i.e., not in an arbitrary or perverse manner without regard to the actual facts or unreasonably or which would lead to a conclusion in the mind of the court that there has been an improper exercise of discretion. Stop. If there is improper exercise of discretion, it is an instance of an abuse of discretion. Stop. There can be abuse of discretion when the administrative order or exercise of discretion smacks of malafide or when it is for any purpose based on irrelevant consideration by ignoring relevant consideration or it is due to a tolerable exercise of power, semicolon, it is unreasonable and there is absence of proportionality. Stop. There could also be an abuse of discretion when there is failure to apply discretion owing to mechanical exercise of power, non-application of mind, acting under dictation or by seeking assistance or advice or there is any usurpation of power. Stop. It is not necessary to dilate upon each of the aforesaid aspects of abuse of discretion in the instant case, as we have observed that the consideration of the impugned orders or manner of exercise of powers is unnecessary, having regard to the answer given by us to point number 3. Stop. Para. Change. 50. However, it would be relevant to refer to one aspect of abuse of discretion, namely usurpation of power. Stop. Usurpation of power arises when a particular discretion vested in a particular authority is exercised by some other authority in whom such power does not lie. Stop. Applying the said principle to the instant case, we note that having regard to the definition of appropriate government and the answer given by us to point number 3, comma, the exercise of discretion and the passing of the impugned orders of remission in the case of respondent numbers 3 to 13 herein was an instance of usurpation of power. Stop. It may be that this court, by its order dated 13/5/2022, passed in writ petition number 135 of 2022, had directed the first respondent, State of Gujarat, to consider the case of respondent number 3 under the 1992 policy of the State of Gujarat, comma, by setting aside the order of the High Court of Gujarat dated 17/7/2019. Stop. What is interesting is that in the said petition, comma, the State of Gujarat had correctly submitted before this court that the appropriate government in the instant case was the State of Maharashtra and not the State